is Paige Underwood, and I want to welcome you to a short video that is being prepared to show you some of the ins and outs regarding the California Farmers Agent Class Action Settlement. And here I have with me Erin Dickinson. She's one of the lead attorneys on the case who's representing plaintiffs in California. So I wanted to give you some extra information for those of you who haven't had the chance to join one of our webinars, or those of you who are just starting now to hear about the case. This video will help you understand what's going on and give you the information if you'd like to be a part of the case. So without further ado, Erin, welcome.
Hello, Paige. Good afternoon. It's so good to see you, and we really appreciate you hosting this informational webinar for everyone. It's been a joy.
Let me ask you, how did you, Erin, originally get familiar with insurance agency litigation and representing agents?
Well, we've been at this a very long time in terms of representing captive insurance agents in cases just like the one we're going to talk about today. Back in 2013, we were hired to bring a class action case on behalf of American family agents. And that sort of started our journey and our knowledge about the captive insurance industry. And so we came to bring the first class action case on behalf of American family agents, and then obviously this second class action on behalf of farmers agents. So it's been nearly a decade since we've been representing agents in issues just like the one we're going to talk about today.
And I think that's really important for agents to know right now, because even though there are lots and lots of attorneys out there, there's actually very few attorneys that specialize in captive agency contract disputes and such. So I think it really bears to your experience, and members and farmers agents will want to know about your experience. So that really lends some great credibility there, that you understand what farmers captive agents go through. So when did you first start representing farmers agents?
So right around the time of our jury verdict in the American family case, we were fortunate enough to win a verdict on behalf of the agents in the American family case back in 2016. And as you can imagine, when that result came about, it was big news in the industry because it was the first of its kind. People had lost that issue many times, but no one had ever won it. And so certainly no one had ever won it at a trial, and no one had ever won it on behalf of a class of agents instead of just an individual agent. So that started our sort of journey of a lot of outreach from different captive agents around the country, some of whom were California agents that worked for farmers. And they told a very compelling factual story that fit very well with legal theories that we knew could be successful. And so we came to represent some California agents that were farmers agents in this current case right around 2016.
Okay. So you've been working on this particular case for six years or so?
It has. It's been 6 years. So in 2016, we began the fact investigation specific to farmers. Every company's a little different. We knew a lot about the captive agency insurance model, but of course, every case is different. So we spent hundreds of hours investigating, talking to farmers agents in California, researching the law that we came to bring this case under, and really getting ready for the case. That obviously spawned years of very, very contentious litigation in which we spent tens of thousands of hours working on the case. But that was the start back in 2016.
I've heard stories from people with complex litigation and class actions that those cases typically take a long time. Like it's just years and years and years of processes to go through. Can you give me a high-level overview of the case from when it started back in 2016, what it's about, and cover that?
Happy to. So we originally, what we fundamentally came to understand was a lot of the captive insurance companies sort of abused the independent contractor classification that a lot of the agents are classified as. So when we started investigating this case about farmers, that was sort of the very similar complaint to what we had alleged in the American Family case, that they call agents independent contractors but misclassify them as such because they keep a lot of control over how the agents did business. And as we learned in American Family and was true at Farmers, is those controls sort of tightened over time to a point where these agents really didn't feel like they were independent contractors any longer. So we came to bring a case under California Labor Code Section 2802 that basically says that if you are treated as an employee, you cannot be made to bear the business expenses of running the company. And you need to be reimbursed for those. So it was a very specific law in California that allowed us to get at, frankly, a better result than we even achieved in the American Family case.
Could you repeat that last line one more time, because it's just so important?
Essentially, the way to look at it is California 2802 protects workers in a number of ways. Anyone treated as an employee, the employer cannot pass along the costs of running that employer's business. And so what we were alleging is when farmers started to treat agents more and more like employees, that they could no longer pass along the costs of running farmers' insurance sales business. And so if it was true that they were treating them more like employees than their classification as independent contractors, they needed to be reimbursed, and they, as the agents, for the expenses of running that business under the law. If they were actually treating the agents as independent contractors, it is legal for the company to require those independent contractors to bear expenses of running their own businesses. But what we came to learn was that it no longer functioned like that at Farmers, that the agents were not allowed to simply just run their own independent businesses, and they were really working for Farmers.
And Smart Office was a big part of that, correct?
It was. There were a number of corporate programs that we came to learn in our case that really drove that. Smart Office was one, the agency growth model was another. Some of these key corporate programs that really put requirements on the agent sales force far beyond what can be required of an independent contractor.
It looks like, from what I've read, that all California farmers agents are included in the class. Are there any agents that are not eligible?
Yes, there are a very small number of agents that will not be eligible, and they basically fall into a few categories. One, any agent that has already litigated this issue and even either won, lost, or settled will not be in this class for obvious reasons. They can't recover twice, or they can't litigate the issue twice. Then there are a few agent groupings, the retail and the seed agents, some of these programs that Farmers ran, that cannot recover only some of the recovery because they were given an initial stipend for some of these expenses already by Farmers. And so there are those. And the third category is simply anyone in the agent class that chooses not to be a part of this settlement, that opts out of it. We obviously hope no one does that. We hope this settlement is adequate for everyone, but if people decide that that's the route they have to go because they have current litigation or something like that, they are not eligible for the benefits of the settlement.
Okay. So just to kind of say that again and reinforce that, if you are an agent and a California agent and you have already litigated with Farmers regarding this subject, or if you are currently in litigation with Farmers on another subject, it's vitally important that you speak to your attorney about this. Because that's not really a decision for the plaintiff's attorneys to advise you on, or for United Farmers Agents Association to advise you on. This is your decision. But if you already are in litigation with Farmers, it's really important to discuss that with your own attorney. Isn't that correct, Erin?
That's correct. We, as the class counsel, cannot advise individuals whether, because of their current litigation, there is such an overlap that they either are or not in this class. So we strongly recommend anybody that is litigating currently against Farmers just to reach out to their own lawyer and obtain advice through that. We certainly have many tools that would give guidance on that subject, but we can't give that kind of advice to individuals.
So I've read a little bit about the case and the settlement, and I've come to understand that this is, first of all, a large settlement, but also that it's kind of broken up into different pieces. And so, could you kind of explain the dollar amounts and the different pieces of this settlement?
Yes, there are three different buckets for this settlement, is the way we kind of phrase it.
Okay.
So there are contractual changes that have a concrete value. And some of those are really important to the agents. I think we'll talk a little bit about those in detail in this conversation. But things such as changing the contract to eliminate the non-solicitation period and things of that nature.
Say that one more time.
Well, it's a really important one. So changing the agent contract such that agents can immediately, if they are left or are terminated, can compete right away.
So that's really important for agents to pick up on that right now. So that is huge. This has never been done before, to not have the 1-year non-compete.
Absolutely. So that first part, and we'll go over, there's a number of contract changes that we put an initial value through an expert of about $15.5 million. So that alone, even though many of just the pure contract changes are in some sense priceless and in some sense just can't be dollar valued and are really important, we were able to put a dollar value on the ones that could. So that's sort of bucket one. Bucket two is a direct payment fund of $40 million. And the direct payment fund was important to us because that fund gets paid to all the California agents, no matter if they make a claim or not. If they stay in this class, they will get a check out of the direct payment fund. So that's bucket number two. Then there is a third bucket that was tethered to the policies and the claims we were talking about earlier with Smart Office and a few of the things that we felt really ran afoul of the independent contractor classification. And that third bucket is $35 million. And agents, to recover in that, need to make a very simple claim and can recover up to $10,000 of additional expense reimbursement in that third bucket. So in total, we're really proud of the relief. It's just under $100 million of relief. It's, in our view, a significant relief that really we felt as fiduciaries to the class, we had the obligation to put before this class when it was offered in settlement.
What do California farmers agents need to do right now?
So on March 29th, the settlement administrator will be sending out notice to all agents in California that worked for a day, anytime between 2013 and the present. So that notice will go out in various forms. It will go out by email and by mail. So all of the California farmers agents need to be on the lookout for that notice to come to them. That essentially triggers a process by which the agents can make a claim into this settlement. And we really need people to make claims. We need people to make claims early, and we need people to really support this settlement for it to have the maximum benefit possible to this class.
I wanted to see if there is a deadline on the claims. Is there a timeline, or can people wait a while? What's the timeline?
Yes, there is a deadline, and it's 100 days from when notice goes out. So 100 days from March 29th, which is July 7th. And while 100 days sounds like a really long time, it actually isn't. We really hope that folks take advantage of essentially the first 30 days to really get out there, make claims, make sure that participation in this is very robust. It only is successful, again, if the agents participate and take advantage of these benefits. And waiting till the last minute is a sure recipe, essentially, for someone making a mistake and not having their claim processed, or having their claim denied and them running out of time. So we really, really want folks to immediately start making claims. So on March 29th, the settlement administrator will be sending out notice to all agents in California that worked for a day, anytime between 2013 and the present. So that notice will go out in various forms. It will go out by email and by mail. So all of the California farmers agents need to be on the lookout for that notice to come to them. That essentially triggers a process by which the agents can make a claim into this settlement. And we really need people to make claims. We need people to make claims early, and we need people to really support this settlement for it to have the maximum benefit possible to this class.
Let's talk just for another moment and hit a couple of the other contract changes in addition to the non-compete going away. What are some other contract changes?
So there were a number of contract changes that really tried to get right at the policies that we thought were very ran afoul of the independent contractor classification. And so I did mention the non-solicitation provision. That was actually sort of what we had heard from agents was very important to them, that once they left or were terminated from farmers, they needed to be able to compete. And so the non-solicitation provision was one of them. The other was doing away with a lot of the policies that existed either in the agency operations manual or smart office or agency growth models. So agency growth model was one of the policies that by the settlement can no longer be used to sort of drive the agent's compensation. While smart office was not technically a part of the settlement doing away with smart office, the farmers did do away with smart office near the end of this litigation. So that was really important. And then some of the requirements in the agency operations manual that really put restrictions on agents and how they were expected to do business by farmers, we really felt strongly that those needed to be changed. Additionally, we wanted training on the independent contractor classification for management so that at farmers, they actually knew what an independent contractor was and how you could treat one. So that is being put into place. And there's a hotline, a place where agents can call if they feel like farmers is not treating them as independent contractors. Through the course of the case, we really learned that none of those things existed at farmers, and they were really important. We also shortened the period of time where an agent gives notice before they leave farmers, because we felt like it was important to agents to be able to make their own choices about when they stayed or when they left farmers. And so some of those things are all getting at more freedom for agents to operate like a true independent contractor. And so what we did was negotiated essentially privacy for making a claim. Farmers will not know, nor will the district managers. And when I say farmers, I mean all Salesforce management employees up to Jeff Daly will not know the identity of any farmer's agent that makes a claim. It is a negotiated term in the settlement. An additional negotiated term is that farmers may not interfere with anyone participating in this settlement. So for example, if anyone at farmers was out there making speeches about, we really don't want you to participate, or if the company won't look favorably on that, that is absolutely in violation of the settlement agreement, and we immediately need to know about it if it ever takes place. But the big point is confidentiality. When agents submit a claim, their identity will not be known to farmers at any time. We worked long and hard over that. The court is very attuned to that issue and expects that part of the settlement agreement to be followed to the letter.
I think a huge aspect that agents really appreciate is the fact that that protection is built in there, because there is a sense of fear with a lot of agents when it comes to saying or doing anything that farmers might perceive as being against the company. So I really appreciate you taking the time to work that into the settlement.
To add to that point, this is a settlement that farmers itself endorses. I think that agents should not be afraid of this settlement in the sense of how you're speaking of it. Farmers, this is a mutually negotiated settlement agreement that farmers wants to succeed as well. So, much unlike some pieces of litigation or participating in some pieces of litigation, this is a result that farmers wants as well. And so I want to make that clear that folks are not doing something disloyal to the company by participating. This is actually something that was mutually negotiated between our side and theirs, and that they want to succeed as much as we do.
And ultimately, whether you're a California agent or not, there are so many good things that are coming out of this settlement that will affect agents nationwide, not just in California, but this is a really big deal and making positive change for good. I've taken a look online at a couple websites that are set up to handle questions for this. Can you tell me a little bit about the websites?
Absolutely. The very first and most important one right now is the settlement website. So that is the official place to go and make claims. And the settlement administrator is an independent administrator that manages this whole process. And they have maintained a website that we'll provide to you in this presentation at www.californiainsuranceagentsettlement.com. And so that's sort of the first place. Then we as lawyers have maintained a website to get information out to the class through the last few months that is really important, sort of the timeline of events, when we might be doing upcoming webinars, when we might have more information or deadlines. And that website is www.farmerinsurancelawsuit.com. I know a lot of you have already maybe visited that website. And the third way is we have set up a dedicated email address that is on that website that you can contact us with specific inquiries at any time. We will have dedicated staff helping agents fill out claim forms if they have questions. So please do utilize those resources. They are all there for questions about claims filing and everything else during this claims period. We are there to make sure that claims get filed correctly and that everybody understands how to do so. We will be hosting upcoming webinars on that. And so we want to make sure that everybody has an opportunity here to take part in this in California.
That's great. Well, Erin, thank you so much again for joining me today to explain the ins and outs of the case. And I want to thank all of you watching, and also check out www.ufaa.com to learn any more information you'd like to about Farmers Agents Association. Have a great day.
Thanks, Paige. Appreciate it.